Hello, everybody.
We're back on Dabney.
This is case 2502019 LT Copper Tree Apartments versus Delano Dabney. Delano Dabney, you spoke with Ms. Cohen. Did you find her to be open and honest with you?
Yes.
And did you understand all the rights in the rights presentation?
Yes.
Ms. Cohen, the terms and conditions?
We don't have any because he said he applied for financial assistance, but I don't have any record of it. And I don't know that he submitted anything to the court.
No, there was nothing submitted to the court. Let me just double check. Last time we were here, let's see. Sir, did you file a Form DC 539?
I'm not sure what the letters mean, but after the first court day, you had given us information on how to file, and I went and I did that for the emergency relief for rent. So I did file that, and it is pending, but I had nothing to submit.
Okay,
to the court.
so I have the form here. Are you raise your right hand? You solemnly swear or affirm the testimony you're about to give us the truth, the whole truth, nothing but the truth, so help you God?
Yes.
And you stated that you filed an application for financial assistance based on the information that I gave you at the presentation of rights?
Yes.
And with which agency did you file an application?
I went to the DHS office.
So the Michigan Department of Health and Human Services?
Yes. And Taylor.
I have the form right here. Would you like to give me permission and consent on the record to sign your name to the form so that I could put that in your court file?
Yes.
Your Honor, I would object. He is supposed to do that within the first 5 days. The court was pretty clear. If he doesn't do it, he's not entitled to the adjournment. I mean, there's, thousands of dollars owed, and he was supposed to do that within 5 days of February 27th.
All right, well, they had to file the application if one has been made within 5 days of the presentation. That's the one thing that's the one glitch about the whole thing is that they require me and I'm required to tell them how to file an application and where to file an application. So if they've already filed an application, they have to give that to me 5 days from the date of the initial hearing. That's if they've already filed one, but if they don't file one until after that fact, the court rule it kind of leaves it in limbo and just leaves it up to me to determine whether or not we should go ahead. It doesn't say that there's anything. So I just treat it as, I'm gonna go ahead and give you the adjournment to see if it gets done, because that's what the court rule does call for. It doesn't say anything about people who file after your first hearing. It just says that by the date of the first hearing, if you have an application pending, then you have to give within 5 days of that date. That's why I always take it on the record right there, that date. But that says they have 5 days after that date if they have one that's pending. But the problem is a lot of people haven't even heard about it until that first date in the first place. So I'm going to adjourn this to.
Doesn't it come in the court papers?
What do you mean?
Well, when they get sent all the papers from the court, I believe that information is in there.
It does, but I didn't write the court rule. The court rule says that if you have an application that's pending at the time of the first hearing, you have 5 days to get that the DC 539 into me. But it doesn't say anything about people who file it after that first court date, because maybe some people are not literate. Maybe they don't read the stuff. I mean, all I'm saying is I physically, that's why I'm required to verbally state all of that. And I think that's why. So I'm just going to adjourn it. Your objection is duly noted, but overruled. I'm going to go ahead and adjourn this to the 26th. And that's going to be the last adjournment then, because that'll be the third time we've been here, but we'll see how it goes. Both of you have a good rest of your day.
Yeah, you too. Thank you so much.
Thank you, Your Honor.
Have a good day. All right, Mr. Mudar,
Yes, Your Honor.
you had the opportunity to speak with Cordero Wright and Angelo Martinez, is that correct?
That is correct, Your Honor.
All righty. And was there any resolution in these matters?
Yes, Your Honor. We have a resolution on both.
All right, Mr. Martinez.
Hi.
Mr.
Hi, Your
Mr.
Honor.
Martinez. When you spoke with Mr. Muda, did you find him to be open and honest with you?
Yes, sir.
Mr. Wright, did you find Mr. Muda to be open and honest with you?
Yeah, he was open, but we had a little bit of discrepancy, and we couldn't kind of figure out why was that, but everything else he was explaining correctly.
All righty. And did both of you understand all of the presentation of rights that I gave last time?
Yes, sir.
Yeah.
All right, very good. Now, with regard to Fairlane Apartments versus Angelo and Latavia Warren and Angelo Martinez, was there a consent judgment, Mr. Murdo?
Yes, Your Honor. So we've got a consent judgment to Angelo Martinez. And, Miss Warren is not currently present, so default to her, but with the same terms, of course, that Angelo Martinez is receiving on the consent.
All righty. And those terms and conditions are?
So we've got a rent to retain possession on this one in the amount of $3,316.28. Court costs in the amount of $171, giving us our grand total $3,487.28. We're providing until March 31st of 2025 to either pay or vacate. And then in paragraph 10, we've got language that indicates that defendant indicates that he's made a payment of $1,902. The payment was made yesterday, and so it's not yet addressed on the above balance, but we're agreeing that to his indication that he did make that payment. And then we've got language that states if defendant pays the balance on or before March 31st of 2025, parties agree to stipulate to set aside this judgment and dismiss this case. Defendant must email plaintiff's counsel to confirm full payment. I have received permission from Mr. Martinez to add his signature to this resolution, and we have went over MCR 4.201J.
And Mr. Martinez, did you hear, understand, and agree to all those terms and conditions?
Yes, sir.
All right, that is granted with regard to the consent judgment and as to the default judgment under the same terms. And send that in via the portal or email.
Understood, Your Honor.
And as to Mr. Wright's matter, was there a consent judgment?
Yes, there is, Your Honor.
All right, and what's the terms and conditions?
So we've got a rent to retain possession in the amount of $5,325.87. We've got court costs in the amount of $171, giving us our grand total of $5,496.87. We've got, we're providing until March 31st of 2025 to either pay or vacate. And then we've got language in paragraph 10 that indicates if defendant pays or vacates on or before March 31st of 2025, parties agree to stipulate to set aside this judgment, dismiss this case. Defendant must email plaintiff's counsel to confirm full payment or having vacated. And then I've received permission from Mr. Wright to add his signature to this resolution, and we have one over MCR 4.201J.
All right, Mr. Wright, did you hear, understand, and agree to those terms and conditions?
I heard and understood things, but I don't had a lot of problems with this, but it kind of just seems like this was my only choice and only route to go. So this was the only thing that I could accept. So, but other than that, we had problems. It's just that it was just like he kind of told me, well, he was giving me this amount, and if I kind of went back to you to kind of ask you some questions about, they had a discrepancy about the money that he said I owed and the people and what they had gave me and the emails that they sent me. So it was just like, I'd rather take the 14 days. And basically he said, if I came back to you, I was only going to get 10. So that's the problem. Other than that, if I knew that
well, first off, I mean, that is correct. I can only give you the statutory 10 days. If he's gonna extend it to the 31st, that's different. Secondly, if he's also including where if you get caught up or you move out, then they will go ahead and set aside the whole case so that it doesn't go on your, basically your credit history, I think is what's the most concerning thing there. And I can't add that. I can't add that kind of language. So it's just a matter of, are you agreeing with the consent judgment terms as they propose them, or are you not? That's all.
Well, I'm just trying to, I mean, see.
There's no just trying to, it's either yes or no. I can't give you any legal advice. So if you want to.
I mean, well, that case, I won't have no choice but to say yes. I mean, y'all go do whatever y'all want to anyway, whatever. It's basically, this is crazy. I mean, I guess I would try,
well,
not trying to legal advice. How would I go about trying to just correct the situation after this? Because things are not right. So I'm going to agree with it, but I just want to be done the right way. So I just want to be able to get somebody to help me out with what was going on.
Well, first off, there's not going to be, I don't know what you mean by, well, they're just going to do whatever you want to do anyway.
Yeah, meaning that they already
listen,
I'm just trying to see how can I go in the right way.
I said, listen, that means stop talking. What I'm going to do if we go to hearing is I'm going to look at the lease, see how much the rent is. And then you're going to show me receipts for rent that you've paid. They're going to testify about which dates they were paid on and which dates they were not paid on and how much the balance is that they say you owe. And then I'm going to ask you under oath, and you're going to be able to say which dates you paid on, show me your receipts for those payments. And then it's just math. It's just me adding up rent payment, minus payment, and here's how much you still owe. It's just simple math. There's not anybody doing anything the way they want to do it or whatever. It's called renting. It's like going to a restaurant. You buy, I don't know, you buy a dinner and then they serve you a dinner on the plate and then you pay them the money and then you eat the dinner. It's just a service. That's all it is. And so this isn't that hard of a case to figure out. It's either did you pay the rent or did you not pay the rent? How much is the rent? That's easy. It's all math. It's just all math.
I know the math.
As long as I have receipts for everything to look at, then it shouldn't be that big of a deal. So if you want to have a hearing, we'll have a hearing. I have no problem with that. But what I'm saying is I just need to know that if you want to take a deal, people take deals for all kinds of reasons. And I don't need to know what the reason is. I don't need to know what your reasoning is behind it. I just need to know that you're voluntarily choosing to go that route. That's all. That's all I need to know. So are you voluntarily choosing to take the option that they offered you? Yes or no?
Well, if we can go to the hearing thing, I mean, I'd rather be right about something than just wrong. So.
Okay, so you want to have the hearing? Okay, not a problem. So we'll set this up. We'll set this up for a hearing. Let's see. What does Friday look like?
Friday we have a lot. We have no informals, but we have a big.
No informals? Right. What about, is it morning and afternoon?
We just have morning, so.
You want to know what? I'm just going to leave and get out the property. This is just something that I'll just take a loss on and have to learn legal.
Well, I was gonna set the hearing for this Friday afternoon.
Yeah, it don't matter. There's no thank you.
I'm sure I can go either way. I can set up for a hearing, which would be this Friday at 1:30. Or if you want to agree to their consent terms that they offered you, you can do that too. I just need to know which one you're choosing.
I guess matter of fact, I'll go with the hearing. I just still want that to be heard. So yes, that'll work.
Okay. So we're at 1:30 here, everybody in person at the courthouse. We'll have the hearing.
Okay.
All right. So everybody come here, be ready to go at 1:30 and make sure that you have whatever receipts, whatever documents that you're going to bring those with you then. All right.
Okay.
So in person. here at the courthouse. And that's gonna be March the 14th.
Yes.
14th, and that'll be at 1:30 p.m. And we'll see everybody then.
Thank you.
Thank you, Your Honor.
Thank you so much for coming out and being with me tonight. Be safe, be well, sleep sweet, and much love.